way through. So for fun, today we're going to have a little exercise at the end of the class. Don't you love surprises? We're going to spend the last 10 minutes doing an exercise, which means we have to kind of hippity hop through the course. Now, I mean, remember, the slides and the things we talk about in class are kind of sort of, kind of FYI, kind of highlight things or whatever. I mean, you do your reading, so it's all in the textbook, right? This is not an original source document. This is my document, the original source. So, we're going to have to hop through the course, and today's class, and I'm going to ask you to take it. And what we're going to do at the last 10 minutes is we're going to break up into 9 groups of 4, not 4 groups of 9, 9 groups of 4. Do a little exercise, and then you're going to email me something. And I will give you all the details. It's fun. Okay, so today's class, what's our first thing? Who's our lawyer? I know you know. Whoever said that. Who's our lawyer? Someone who didn't tell me. Who's our lawyer today? Lawyer, on the screen. Who is it? Okay, someone who does know. Consigliere. And consigliere is who is it?
Tom something?
Yeah, but what,
The lawyer, the personal lawyer of the Godfather.
So the Godfather movies, right? So he's the personal lawyer to the family.
Yeah.
The, whatever the name is, the Corleone, exactly, the Corleone family. And so what kind of lawyer is Tom Hayden? Now remember, he's like an adopted son, right? So he's part of the family, but he's the lawyer for the family, so he handles all their legal stuff. So what kind of lawyer is he from our perspective, from ethics? What kind of job does he do? Hey, Jill.
He's the kind of lawyer that gives the lawyers bad names, and he probably bends the law quite much to benefit his clients.
He's kind of on the borderline, maybe a little gray area. A little gray area in terms of his practice because he has one client, right? The family. And the family business, is whatever the mom says. Okay, so that's the kind of lawyer he is. Okay, let's get going. Let's do our joke now. So we put the decks for later. Joke, let's go. Joke. We laugh at ourselves because we make jokes. Look one up online. Okay, let's go. Joke today. The lawyer dies. It's always about death, right? Death is dismemberment. Lawyer dies, goes to heaven. That's the first part. Lawyer dies, goes to heaven. And he's standing at the gates waiting to go into heaven. And there's a gatekeeper at the gates with a little clipboard. And he's checking off names. And he says, "Oh, Mr. Barrister, welcome. You're one of our most esteemed members here in heaven." The lawyer says, "Well, I'm happy to hear that. Is it because of my prowess in the courtroom? Is it because of my intellectual acumen?" And the gatekeeper says, no, it's because one of our oldest members." And he said, "You died at 80. How is that the oldest?" He said, "You died at 80? According to your dockets, you're 106. Dockets. What's a docket? Oh, well then you won't get the joke. Yeah, what's a docket?
It's a timing sheet.
It's a timing sheet. So when you work, you keep track of your time in 6-minute increments. Okay? Got it? All right, there you go.
It's too early in the morning.
Is it too early? Hang in there. It gets better. No, that's not. Okay. So today we're talking, hang on, I'll just go through all my usual rigmarole. Okay, disclaimer. Today we're talking about civility, confidentiality and privilege, and responsibility to other lawyers, and we're leaving the last 10 minutes for fun and games. Okay. So, civility. So civility is one of our hallmarks, right? We have to be civil to each other, civil to the court, civil to the other side, civil especially to self-represented people or unrepresented. Because you have a number of roles you have to play, right? You have a public interest. You may work on a settlement. You might be a legal aid lawyer. You might be a business lawyer. Any of those hats you wear, you have to maintain that cloak of civility. Remember, no matter where you practice, you carry your ethical obligations with you. And so we have this notion of, are you just a zealous advocate or a skilled technician? Are you just someone who just has to apply the law, read the law, give advice, and move on? No, there's also this notion of being more civil and being a collegial with your colleagues and friends, with whom you work, judges, and so on. And we know we have that tension with the Brown model, right, which we've seen now a few times, and which is kind of this underlying current that comes up over and over again, where the Brown model says you should be zealous and you should pursue your client's rights at all hazards. Do not disregard any alarm you may cause, and that has to be tempered, we know, with this notion of civility. So there's a balance you have to make. If you follow the Brown model, you still have to have overlay of the notion of civility. But there are critiques, and we know this. Who's one critic of Brown? Pardon? Yes. Who else is Nadia? Who else is? Trevor Fair is a big critic, right? Because he wrote that 100-page article criticizing the traditional model. And the critics, including Fair, say something like, yeah, but being that zealous advocate doesn't take into effect other parties, other interests, the notion of civility as well, and the increasing number of self-reps, right? So you can't really put on that full steam zealousness with a self-rep. You can see the imbalance of power. Now this case, as I am looking, is not in your text, but this is just a summary of an example of a case. And here's the key here. Is the lawyer is accused of having the client attend court in a military uniform when that wasn't the case. And the decision says that this is a distinction to be made between revealing something to one's credit, revealing someone to a credit, versus continuing a false pretense when the counsel knows the court is deluded. So in that case, counsel knew that his client showed up in full military, proper oppressive regalia when that wasn't the case. So it's the point of the case is, let's distinguish between not having to reveal something that isn't relevant versus an ongoing pretense or mistake. That is not considered a civil manner in which to practice before the court, because you're an officer of the court. And we know the model code even says something like that to us. A lawyer must avoid sharp practice. What's sharp practice? What's sharp practice? What's sharp? What do you think sharp practice is? What does it sound like? Joe.
Basically, it sounds to me like going at it with daggers, and you continue with the analogy.
Yeah.
And it's being maybe a little bit too pointed, too cutting, too harsh.
It's a little bit too Brown-esque. So we have to avoid sharp practice. And you must not take advantage of little slips. A person has the wrong court file number, you can't take advantage of that. Someone, irregularities, mistakes on the part of the other lawyer. That's not civil. You call your friend, you say, hey, listen, I saw your document. I think you got the wrong court file number. Let's get this thing going forward, as opposed to saying, ooh, wrong court file number, we're going to have that document struck. That might be considered sharp practice. Taking advantage, being quicker cutting on small matters that don't go to the heart of the issue. And section, that's 7.2-2. And related to that, or limits to zealous advocacy, related to that is 5.1-2, which says, thou shalt not, must not, shall not, deliberately refrain from informing a tribunal of any binding authority that's directly on point. So, you're going to court, we had this case, right, where the lawyer withheld, and and the judge knew about it, and is the same lawyer on the relevant precedent that doesn't bring forward, so long you didn't hear about it, right? So that's not considered proper behavior and, hello? We're all good. Thank you. Proper behavior and it's more than just not sharp practice. It makes you look like you're either not smart enough to know all the precedents or withholding something that goes against your client's interest. Neither of those are acceptable. So we have a case of an example, a case of the Zellers. Zellers is gone now. It used to be like a store that was like a discount store.
Before you go on to that, just a quick.
Jude, is it Jude?
Yeah.
G.
Oh,
Yeah, no, you gotta give me this because
you're good.
I leave here, I forget what because
You're good. I'm just thinking how. How does one not practice sharp practice when it comes to it, when you need to? I mean, do they hold that against you if that's what you need to do for your client at that moment?
I don't know. It depends, right? It depends. If you have a philosophical, theoretical approach to the practice of law that says, you know what, here's an example of where the other side, did something wrong, and I have to take this step for my client. Why? You might have a contextual thing going on. You might have a client who's ill and is limited time. You might have a building that's going to be demolished unless you do something, and here's something that you can do to slow things down. So it all depends. You have to make that judgment call. Like, that's your problem. You have to make that judgment call. And you have to stop and think, oh man, I've got this ethical dilemma. I know I shouldn't have sharp practice, because that's not proper. You're next. That's not proper. But my client's interest is this. Where do I fall? I don't know. It's a gray area, right? And what do you do when you can't decide where to fall?
What? Oh, you make a call.
You get some input, right? Don't be your own counselor.
I just want to know, how do you bifurcate? How do you demarcate or bifurcate? Because sharp as a term is basically subjective. What is sharp to you might not be sharp to me. Now, I mean, if there's no codification, even general codification, how do you follow a set guideline, set principles?
Yeah. I mean, there is no answer, right? What do you have to do? You have to satisfy yourself. Maybe you go and look at the cases, and we're going to have one coming up in a minute, Schreiber and Mulrooney, of an example of sharp practice. You say, oh, well, that's my situation, so maybe I shouldn't do that. You talk to your senior partner. You talk to your mother, right? You also have to carry your own, like, you have to be able to go home and sleep at night, not be thinking, oh man, I really shouldn't have done that kind of thing, right? Like, that's your own internal ethical clock that you have to carry with you. But there's no right answer. Like, there's no line that says this is yes and this is no. Like, there isn't.
It might also be worth considering that the example that you gave a moment ago, if somebody has the wrong file number 567, I know I don't have to respond to that, then this takes it into the wasting the court's time and delaying access to justice for other people who are lined up behind you to get into court.
Frivolous indexation, exactly. So all of that, and no judge is going to be happy with you. Right? That's the other thing, is you show up and say, I want to have this case dismissed, wrong file number, and they'll say, counselor, really, call your friend and work that out because you're wasting court time. So you've got that other layer of your duty as an officer of the court, not to waste your time. And by the way, it's going to cost your client money for you to take that step. That's consideration as well. So, I mean, all good stuff, no right answer, but the important thing is you identify the problem, you think about it, you get some input, you figure it out, and then you do something about it, or you don't do something about it. Depends on what you're going to do. So, Zeller's case, page 395. So what happens is this mom is shopping with her son pinches something, it's like $10 or something. And what happens is, and the page reference is page 395, and what happens is the counsel for Zeller, in-house counsel, right? Like a store, like a commercial, says, you're gonna pay me Pardon? You have to pay us, right? Because your son pinched something in the store. And, and so what happens is, there's a return of payment. What's unjust enrichment? Well, I was looking at you, so you're next. Maybe that was sharp practice on the part of that lawyer. What'd she say? You agree? So she gets her payment back because the lawyer takes advantage of a mom. She's like, my kid pinched something, oh no. Like, you're embarrassed. Who's got kids? Right? Like, it's not a good day when your son pinches something from the store. So she's going, I'm going to pay whatever. But what happens is, the law actually says the parents are not liable for their children's actions unless there's negligence, right? So the lawyer took advantage of that situation, right? And the court said, no, it's not going to risk return unjust.
The last paragraph where it says, it appeared to have been treated as a sort of test case, $100 million, blah, blah, blah. And I think that was a really significant point in why they came down the decision to say that, okay, this is your recovery model, it ain't gonna fly.
Okay, what's a test case? Good point. What's a test case? What's a test case? Casino.
I think it's where they establish tests for implied pieces
Going forward, right? Because there's nothing. There's just no precedent to take. So we're going to test this, see how it lands, and so on. So that might be part of it. But I think the underlying sort of current for this particular case is mom, little boy, $10, pen, something, I forget, whatever it is that he pinched, right? So there was that kind of, if you're going to have a test case, like, let's have a serious test case in case someone hacks your computer, whatever, I don't know. But the idea was mom, little boy, right? Like it all just kind of stank of a sharp practice. So good point. That's Zellers. Okay, and remember Lariker? Remember way back, first class, second class Lariker? And this was the lawyer who writes 2 letters. He has a blog, and this fellow was found to be liable for professional misconduct, sharp practice, that notion of behaving in a way that reflects poorly on the rest of us. So we all stand behind you. And so your ethics and your approach to your practice, not sharp practice, will cover not just your time in court, right from the beginning, right? So our first case here talks about ethics and discovery. What's discovery? Anyone ever done a discovery process? So discovery in civil litigation, you get to discover the other side's case. You exchange documents, you have interviews, you have reviews and so on. So your ethics start early on, right? And discovery is long before you get to the hearing, right? Or to the trial. And so what happens in this case is Grossman case is page 402. Can I get a reader for 402, 402? Can I get a reader for ethics and discovery, page 402? 401 is the start of the case, and can I get reader? Sorry, no, you're next. Shamim? Okay, so page 400, just read the intro, read J up into the 4 little dots. Yeah?
Could you say again?
Page 401. See the case? Reed is the judge. So just read those little 3 paragraphs there.
The action arises out of the death of Howard Grossman, who is claimed to have been lost while a patient in the Toronto General Hospital. It is alleged that his body was discovered after 12 days in an air duct shaft in the hospital. The defense entered by the hospital for itself and its staff amounts to a general traverse. Not even the death was directly admitted. That document gave a hint of what was in store for plaintiffs. The hospital's affidavit on production revealed only one thing: the hospital had no objection to producing the deceased hospital record. That was the only entry made in the first part of the first schedule of the form, required by the rules of practice.
Thank you. So what does that tell you about what this judge is going to find in this case? What does that introduction tell you?
That there was negligence on the part of the hospital.
Yeah, negligence that even maybe went a little bit further, right? Because think about it. Think about it. Your father or uncle dies in a hospital. They can't find him. Like, they can't find his body. They can't find his body. And it takes 12 days. You were at home freaking out. You're trying to have a funeral, you know, your aunt is crying. And they can't find the guy until they find him 12 days later in an air shaft. Like, not in the morgue, not in a wrong room. Air shaft? Like, what the hell's going on here, right, with this hospital? And so what do they do when they sue the hospital? Obviously, they sue the hospital, and when you have discovery, you have an affidavit of documents, which is somebody from the hospital, some CEO or some person that has authority, swears an affidavit to say, here are all the documents as part of the discovery process that I have to give you, full disclosure, you give me yours, and then we go to, you know, to court, to trial. And they say, here's my affidavit of documents, which can include hundreds of documents. They have one. They have one.
The chart.
A chart or something, right?
Medical
And the
chart.
court says, no, counsel for the hospital. That is sharp practice. They don't call it sharp practice. It's inappropriate practice to say that. There is no way that can be the only, like, I mean, just think about it when you go to the hospitals, like, you know, reams of paper and things that you sign. So they only produce the medical records and the affidavit documents. They claim privilege. Oh, we're giving you nothing else. Everything else is privilege. And the court says in the commentary, you have to, you as a lawyer, and maybe your CEO or whoever's swearing the affidavit for the hospital says, claim privilege and everything else. I'm your client. Do what I say. I want to have only one document in this. And the court says, no. The obligations of a lawyer to ensure clients are forthcoming upholds these things. Integrity of the system. Reasonable investigation. And then the decision is in favor of the family, of course, solicitor and client costs. So you can get costs if you're successful. Solicitor and client costs are much higher costs as a penalty for the client.
So, therefore, in this respect, the court is saying you as a lawyer have a higher level of responsibility than, for example, a company.
Is it a higher level? Or is it the same level that every lawyer should have? I don't care if your client is a big, fat, huge hospital.
No, yes, the lawyer has that level compared to the company or the CEO.
Right, who is just the client,
Yeah.
right? Who's saying, no, just give them one document, claim privilege on the other 14,000 documents. And you as a lawyer have to have that conversation with the client. Say, dude, it's not going to work, right? Right? And then the lawyer may have to withdraw if you have serious doubts about what your client is doing.
Right,
We've seen
okay.
that before, right?
Yeah.
Okay, right. So your ethics continue. Now you're in negotiation stage. You somehow got through discovery, you got everything, you're looking at everything, you're trying to prepare. Where's this case going to go? Are we going to settle? So in negotiations, 3.2-4 says you must advise and encourage a client to compromise or settle whenever possible. We know why. Why? What's one reason? There's always a choice. Court's time. Number 2.
Limited resources.
Limited resources. Number 3. Cost of litigation process. Petra.
Administration of justice.
Administration of justice.
It overall makes the system more efficient the more quickly cases
Because
are.
there are serious issues back here in the queue waiting to go to court that maybe someone should decide those and have a precedent and have advanced the law and so forth. Okay, good. Those are all good reasons. So our model code, and look it up in Ontario, or if you practice in Alberta, I'm going to tell you you're going to find the same thing. You're going to find a mandatory must advise and encourage self for all those good reasons. Plus, if you've ever been in a litigation situation yourself, it's stressful. You're thinking about it, you're like, as the client. As the lawyer, you're going, woo-hoo, this is great, I'm feeling a lot of time. As the client, you're thinking about it, your client's stressed, worried, waiting, delays. It's like it's a strange financially and emotionally. Not just for the individual family law client, right? The CEO of the bank or the hospital also is thinking, how's this going to, reputational, what about future, and so on. So there's that intention. Yeah. So there's this notion behind the ethics in negotiation is representing the client has certain limits on settlement when it's not the case. Is it appropriate? Hands up. Let's vote. Is your client says to you, settle this thing. I've had it. I'm sick of it. Settle it for $50,000. I'm out of here. Can you say to the other side, my client will settle, but not for a penny less than $60,000? Can you say it? Yes. Nope, that's not what your client said. Hands up. Nope, you can't say it. Okay, why can't you? Chandy. Why do you like? What do you think?
I think the law has to go by as per the instructions or as per the capacity of the client, the purposes and whenever some monitoring kind of business will be.
Yeah, okay. So you have to define instructions, right? Yeah, for sure. Obviously. Who else has thought? Petra.
Well, I think it makes sense to say 60 because it's negotiation. So you just come outright to the client and the other party not pay like this. They might want to meet you halfway.
Sure.
So they
Sure,
will-
right? Like that's just normal.
They feel cheated and
That's more normal negotiation practice. You go back and forth. No one's happy because everybody gives something up, right? Gee,
You
can you take up for me? Don't have to.
today.
Okay, go.
Technically, I think that I saw something about the rules where I think the lawyer would be responsible if he offered more. He would be liable for that extra amount,
Well,
technically.
okay. Yes, I'm talking about the one willing to accept.
Oh,
Yeah. Yeah, so I mean, sure, negotiation, we all do that. When you buy a car, or when you buy a, can you pass that? When you buy a car, whatever, you negotiate, whatever. But there's a difference between saying, we'll settle at 60, and saying, my client refuses for a penny less than 60. So that's your representation, right? The difference is, one is to say, here's our starting point, let's talk. Excuse me. Another is to say, I'm not going to budge because it's 60 when really you know it's 50. The representation is different, right? The communication you're having with the other side. Because then the guy says, oh, 60, well, there's no way I'm walking away. Your client says, hang on a second. I didn't say 60, I said 50. Why did you settle that settlement and going back to some little trick? So ethics in negotiation, ongoing. Ethics at trial. Your ethics go with you constantly, right? So in trial, you have to prepare witnesses. Often you have to prepare witnesses. And there's an ethical component to that. Let's say you're preparing a witness. How far can you go to prepare your witness? So, for example, gosh, there's a... Who's ever prepared a witness for trial? So, high level, how would you go about it? Cassie?
How we go about it? Basically just going through the facts of the case and
Yeah.
telling what not to say.
Well, it's part of it's doing what?
Telling him not what to say,
Right.
like basically keeping it relevant to the facts.
Right. Exactly. Okay, let's go to page 411 of your text. Right, I think what you've said basically is sort of the kernel, the heart of it. You don't tell your client what to say. Like, you don't tell your client what to say. Let's go through some of these examples. Okay, hands up. A. Read it out loud and then tell me what do you think. Someone. Page 411. I need a reader. I need a reader. Look in this area. I need a reader. No, page 411. Vanessa, you don't have the book. Page 411. So we're asking questions about where are your ethics at trial, preparing for trial? Go. Nice and loud.
when you say you saw someone that might look at you that you to say that, in fact, you were pretty sure the person who saw was the defendant.
Is that okay, witness prep? Hands up, yes. Hands up, no. Right, it goes to your point. It's highly suggestive of what their answer should be, right? That's called coaching. Can't do it, can't coach your client. Okay, hands up. When you testify tomorrow, in addition to telling the truth, make sure you typically only answer the question you are asked. On side, yes? Something wrong with that? I think it's on side. Right? Okay, next one. I will be asking questions. The other side lawyer will be asking questions. If a contract, the judge might ask you questions. On side? Off side. You guys got this. So page 411, you've got a series of questions. So the witness prep, your ethics carry on to not coaching your client or your witness. It could be your witnesses, that's your client, right? You'd be calling other witnesses. Not coaching or directing what their evidence would be. But you're right, you review the evidence, the facts, the documents, dates, refresh them, calm them down. It's freaking out. Nothing more than that. And get them ready for cross-examination. Yeah, which is like the bigger job. That's a bigger job, sure. Okay. Importance of, speaking of cross-examination, it's like I planned it, right? The extent of cross-examination must be relevant. Must not be, what's cross-examination? Everybody knows, right? Yeah. Must not be repetitious, prejudicial, probative. You can't put a question where there's no evidentiary foundation. You can pursue a hypothesis as long as it's honestly held. And you can't put forth theories that are known to be false. Page 412. What's on 412? We just did 411. What's on page 4? Yeah, cross-examination. So what happens in cross-examination, you can go too far, right? So we have a criminal case, RVR 1954. And it's a difficult case. It's a criminal case on RVR page 416. And here's what happens, right? Crown Counsel is cross-examining the accused. Fine. All part of the process. So far, so good. And it's a horrible case, right? Incest and so on. And the Crown is a vigorous cross-examination. Vigorous. And in cross-examination, you're given a lot of latitude. You know, I mean, it's going to take a lot for someone to stop a cross-examination. But what does she do? She uses a sarcastic tone. She says, do you want me to believe that as well? And she says, you were lying, weren't you? And comments like, let's try and be honest, shall we? And so what happens is the court says, you know what, that cross-examination went too far. It didn't meet all of the elements of cross-examination. You can test the evidence, you can put things to the person in good faith and so forth. This one went too far, and the conviction is set aside. So that's a real world, serious negative consequence of overzealous cross-examination. RBR.
Professor, may I ask you a question? Does it come to this because the other side did not object enough?
You know, that's a good point, right? Because your job as defense, I guess in that case criminal defense, is you might object. You've asked that question before. My client wouldn't know that answer if you say, what was the police, you know, whatever, and doing and so forth. So that's one of the checks and balances we have, right? Is when there's an overly vigorous cross-examination, civil or criminal, the defense has an opportunity to object, and you have to state why you're objecting to the question, and the judge will say, good objection, don't answer, overruled, go ahead and answer. So you have that kind of safeguard in place. In this case, I don't know. Maybe if you read the case, it might have some details about that. I would guess that if objections were overruled and then this person continued in this manner, maybe the judge wasn't active enough.
That's what I was thinking.
That could be, yeah.
That's what I was thinking.
But it's in your book, so you can have that as a reference point. Representations about the law. Well, this is that case we just talked about, right? The most relevant authority wasn't cited by either party. Mm-hmm. No one raises it, right? The judge knows about the case. She's waiting. When are they going to raise this case that I happen to know is bang on, relevant, current? No one's going to raise it.
And you were the counsel.
And you're the counsel on the case, so you can't even say, oops, I didn't catch that one in my feet. Right? So the case talks about the duties of counsel, and again, this award is solicitor and client costs, which is a heftier award of costs to offset the costs of others. So, what do you do? What do you do? Have I asked you this question? What do you do? It's 8 a.m., you're going to court? It's 8 a.m., you're going to jump in the car and drive to Brampton or Milton or some crazy place for emotion. And you're in the car and you get a text from your park before you answer the text, right? Don't drive. The text that says, oh, guess what? Supreme Court of Canada had a decision this morning. They just released it, and it's bang on our facts, and it goes against us. And your office tells you this. What do? You get to Milton for your motion. What do? What do? So you're all set to go. You've got a brilliant argument that you worked on all night, and here's a case that's going to steer you from the Supreme Court, so you know it's binding, right? What are you going to do? What do you do?
Just pretend you didn't get.
Yeah.
Whoa, one at a time.
Yeah, just pretend that you didn't get the decision.
There's one. Anyone else? Joe?
I might look at the dissent and see if there's anything from the dissent.
Did your pen out? What do you think?
Well, just to basically look at if that you can distinguish between the facts and see how.
So, this decision tells us you do have to raise it. I don't care if it skews your side. You do have to raise it, right? So you do have to raise it. That is if in good, honest, and good faith, you actually know about it. Maybe you didn't get a text from your office. And you say, I've been driving to Milton. How was I supposed to read the Supreme Court of Canada decision? But what can happen is, this happens sometimes. The judge comes in and says, counsel, before we start today, I know the Supreme Court of Canada just came down with a decision. Take 15 minutes, read it, and come back and make sure you argue it as part of your submissions, right? And by the way, 15 minutes for a Supreme Court of Canada case, which runs 100 plus pages. Good luck. Hope you're a fast reader. Hope they have a good, head note or whatever. But these other ideas, read the dissent, right? Maybe you can squirm something there. Distinguish the crap out of it, right? Find every way in which, if it's in your favor, it is the best decision the Supreme Court ever made. We have to follow it. And if it's not in your favor, you say, oh, but it can be distinguished. And let's face it, every case can be distinguished. And just drill in and distinguish the crap. That's a technical term for crap. Okay, yeah, or else you're going to have this problem. So Alice Woolley, one of our authors, writes quite a bit about many things, many things. She's a professor of law in Calgary? Does that sound right? Anybody know? I think it's Calgary. And so she writes quite a bit about civility. It's all in the textbook. You can read about her, pages 433 to 437. And she has a lot of concerns about civility, politeness, courtesy, good manners, avoid discourteous conduct, comments, and so forth. Lots of ethical issues. And she mentions Groya, right? Remember the Groya? And as promised, Schreiber and Mulrooney. Who is the Mulrooney in this case? Who's the Mulrooney in this case? Is that name right now?
I want to say the guy who put the cash stuff down below it, but I'll say
Potato, right?
Yeah.
So Brian Mulrooney was the prime minister of this country for a period of time in the Dark Ages. And Karl-Heinz Schreiber sued Mulrooney for exchange of money, some allegations of bribery and what have you. It's a whole big messy thing, right? And so what happens is, so he's suing him, right? It's a civil action. And default judgment is entered at some point during the process. What's default judgment?
Doesn't come to court, and the judge rules in favor of the
The other side has defaulted in something, usually not filing a defense or not coming to court or whatever. You say, well, They didn't bother to, challenge my case. I win by default. It's called default, summary judgment default judgment. And, well, summary judgment is different, so let's just go with default judgment. So, I forget which side, I think it's the Shriver side, shows up and says, default judgment, thank you very much. And the court says that you're taking advantage of a technicality because the 30 days have elapsed, no defense is filed, boom, deadline missed, give me judgment. Because why? Because when the other side says, hang on, I want to set aside this default judgment, this is not right. Why? There was an ongoing dispute about jurisdiction, so they were talking. They weren't like radio silence, never heard of anything from the other side. They were talking about jurisdiction. Is it Ontario? Is it Calgary? Is it Alberta? They were talking about that. They were trying to settle the terms of the order. But while they're doing all this stuff, Shriver says, oh, let's go and get default judgment. We're talking, we're negotiating, we're debating. Let's go get default judgment. So that's considered sharp practice. The court set aside the default judgment because it's inappropriate. It was sharp practice taking advantage of a situation when there's all this other stuff going on. And guess what? There's an undertaking not to note in default. So while they're having all these conversations, negotiations, debates, they say, oh, by the way, look at it. You have my undertaking, which is a promise. It's your professional promise. I won't note you in default until we sort all this junk out. I know 30 days is going to elapse. So in the face of that, they know in default. And the court says it does not lie in the mouth of lawyer to say, well, those are my client's instructions. Right? Because your obligation is to have a discussion with your client, talk about, hey, dude, you can't do sharp practice crap. Don't write that crap. I can't. So there's your case. And our model code, not surprisingly, has something similar. It says when acting as an advocate, a lawyer must represent the client resolutely, honorably, and so forth, with candor, fairness, courtesy, and respect. All those good things, right? Okay. So back to Groya. Okay, so we have Groya. And we know the case about Mr. Groya, right? So the Law Society initiates their own investigation and prosecute for discipline Joe Groya. Back in 2001. So this is like 17 years later. It makes its way up to the Supreme Court of Canada. These are all great steps that are taken. And the Supreme Court of Canada rules 6-3. So the Supreme Court of Canada is always sitting in odd numbers, right? So they can never be deadlocked. It's always 7, 9, whatever. So in this case, it's 9, and they split 6-3. So a pretty good majority rules that an appeal panel of the Law Society of Ontario came to an unreasonable conclusion that Groya engaged in professional misconduct. Right? Remember Groya? Right? During the defense of John Felderhoff. And they have a test for incivility. When do you cross? We love tests. If a case gives you a test, brilliant. You can take it, you can use it next time. Put your facts against it and test it. And the court says, the majority says, a trial is not a tea party. I like the way the Supreme Court of Canada writes these things, right? They take a little creative writing. It's not a tea party. You don't hold up your pinky. You don't eat scones, and clotted cream. It's not all this. It can be vigorous, it can be confrontational, it can be advocacy, but at all times, it has to be civil. It has to be civil, right? Civility. We wear it, we take it, we use it at discovery, at negotiation, at trial, and certainly at the Supreme Court of Canada. Uncivil courtroom communication constitutes professional misconduct if fundamentally contextual and fact specific. So it's always an analysis on the facts. That's why we never can say what's going to happen for sure. It depends. Give me your context. Give me your facts. That's why you can argue it in your favor or not. And you have to take the context of all surrounding circumstances. So the Supreme Court adopts the test for incivility by the appeal panel that was stated at the Law Society, and they say the approach has to be flexible and precise. Good luck, right? You can't have a rigid definition of what incivility is. It's always case specific. So Supreme Court of Canada, that definition. Okay. The rules give us a bunch of positive obligations for lawyers. Encourage settlement, carried out undertakings, make a promise, fulfill it. You taught your child when they were 3 that you make a promise, you keep your promise, right? Be accurate, candid, comprehensive in presenting the client's case. So 5.1-2 also has a long laundry list of like, I don't know, a dozen or something list of things that you should not do. You can't be motivated by malice. That's that sharp craft description, right? You can't do anything dishonest. You can't appear if there's impartiality, and the list goes from A to O, whatever number that is, of things that thou shalt not do. Your client insists, you say, dude, it's sharp practice, I can't do it. Your client insists, you may have to be faced with the issue of withdrawal. And we don't want to withdraw easily or quickly. Why not? Why do you have to think long and hard before withdrawing? What's one reason? What's one reason? Oh, one at a time. Jenny.
Irreparable loss.
Sure, might set you back. You have to start over again. Jenny. What if you're the last lawyer in town? Right? Remember that concept? What's your client supposed to do? Drive 2 hours to the next town for every meeting kind of thing, right? Yeah. Delay in the process generally, those kinds of things, right? Did you have a comment?
Expensive.
Sure, because what happens when you withdraw and the next lawyer comes up, he needs a month just to catch up to where the proceedings is. So all those reasons. So think long and hard. But sometimes you have to withdraw. If the client wishes you to do a course of action that will involve a breach of your own rules, you have to refuse. Try to prevent it. If they persist, you have to withdraw. You may seek legal. But if you do, you have to minimize expense and transfer the file to a new lawyer. That's just the reality of it, and it's going to be time and money. Sometimes you have to withdraw. Obligatory withdrawal. You are required to withdraw. The rules say, too bad, you want the case, you want the billings, you want the client, too bad for you. Obligatory withdrawal. Client fires you. You know, it happens. It doesn't happen every day, but it does happen. The client has some reason. Who knows? Look, either I'm not happy with you or I'm perfectly happy, but my cousin just said he'd take the case for free or something. So client fires you, you have to withdraw. The client instructs you to do something contrary to your duties and insists, even though you try and talk him down the ledge. The client is guilty of dishonorable conduct or acts only to injure or harass the other side, frivolous and vexatious. Can't do it. Or you're not competent. We talked about competency the other day. Okay, let's move on. Oh, Cunningham. Yeah, Cunningham. Page 219. There's just an example of a case of withdrawal. My case of withdrawal. Okay. Cunningham. Let me just see. I just want to go a little bit. We're okay. We're totally. All right. Now we're going to talk about confidentiality and privilege. So 2 very important concepts that permeate everything you do as relates to your client. So we just talked about civility in court, in trial, in negotiation, and so on. But this has to do with your relationship with your client and the conversations that you have with your client. So confidentiality. Why do we need confidentiality? Remember way back when we talked about in this class, we said, if your client doesn't tell you everything, how are you supposed to mount a proper offense, defense, depends on what you're doing for the client. And how can they tell you everything with a high level of security that you will keep it protected? Confidentiality. For the system to operate successfully, lawyers must be able to represent their clients efficiently, only if they have access to everything, all facts, and the client will not have that sense of comfort to retain you if they don't feel that what they tell you is confidential. Confidentiality, protect the right of privacy. It's different than solicitor-client privilege. We'll get to that. It's owed to casual, current, and former clients. What does that mean? So confidentiality. What's a casual client? What did we say about a casual client?
For example, you
You're
need
next.
someone on social media.
Yeah, sorry, again?
For example, you need someone on social media. There's reasonable violence in
Cocktail. It's that dreaded cocktail party. It's the cocktail party. You're minding your own business with a martini in your hand, and some guy starts talking to you about, oh, it was an accident. What can I do about it? That kind of thing, right? That's your casual client. Remember we talked about what's the definition of client in our model code? Who remembers? What's the definition?
A client who believes that they are actually retaining him.
Definition of 1.1, a client who's reasonably confused. I'm not quoting that one, but reasonably, but it's that dreaded cocktail party. Guess what? You owe a duty of confidentiality. Look at, someone walks up to you and starts telling you, their problems in life story. You say, dude, I can't handle this. That's not my area of law. I can't work for you. Here's the name of a guy, that I know that does intellectual property, blah, blah, blah. You still have to keep that cocktail party conversation. Casual. Current client, former client. We'll look at some case law. Let's face it out more thoroughly. And this is owed even on matters of public record. So just because the client says, I'm going to tweet all about my case because I received injustice and so forth, and they can do that, and it's public, I think. Tweeting is public, considered public. You still can't. You still can't comment. I don't care if it's out on Twitter. What else is there? Twitter, blog, all that nonsense. If you work for the government, you have the same, right? If you're in-house counsel, you have the same obligations. There's a whistleblower policy which can apply. Whistleblower has some protections, but if you're in-house counsel, your duties of confidentiality remain in-house, in government, in corporate, what have you. Your client is still your client. And our model code at 3.1, 3.3-1. Remember, rule 3 is the big fat rule. It's got all the good stuff. The other stuff's good, but it's sort of jam-packed with a lot of our obligations and duties, right? It has all the stuff about conflicts and competency and confidentiality and all that good stuff, right? So it says a lawyer must, mandatory, we're lawyers, language matters, must, at all times, so, blank, hold in strict confidence all information concerning the business and affairs of a client acquired in the course of the professional relationship and must not divulge unless expressed or impliedly authorized by the client. What do you think? Are you going to rely on an implied authorization by the client? You're shaking your head. Why?
Well, I think that what you think could be implied may not be.
What they imply may not be what you infer. Yeah. What do you think?
Well, the same information.
Yeah. You're on shaky ground.
It exposes you.
Get it in.
It exposes you to
And Rocky?
It exposes you to possible litigation in future. Okay.
Right? Hello, Law Society. And also remember, whose side do you think they might take? You, the trained lawyer who should know better, or maybe your client who's vulnerable and relying on you, right? And we know that they already take the client's perspective, at least when you meet at the cocktail party. You already know that, right? So I would say, you know what? Maybe not so much implied. Let's go with express. Written, email, fax, laminated, frame it, put it on your wall. So that's express, right? Yes, you may discuss this. Oh, sorry. Required to be delivered to the Law Society, right? Because if there's an investigation, you don't say no, or otherwise, or required by law. So if you get a court order compelling you to disclose something, too bad for you, client. I've got a judge who's heard all the facts and made a decision compelling me. I'm an officer of the court. I don't have a choice. Too bad for you. And you can do it in a sealed envelope and protect that. Right? We have, oh, guess what? that absolute thou shalt must at all times remain everything you hear confidential blanket statement, guess what? There are exceptions. There are exceptions. So now you got even more gray area to deal with. And we have some well-established exceptions. Some well-established exceptions to that hard rule. And they are described as the following. One exclusion, so we have to exclude certain kinds of information from that all-encompassing blanket rule of confidentiality. And we have two exceptions. It's semantics, right? Public safety and innocence at stake. So the courts have recognized some cases where that cast iron hard rule of everything is confidential, take it to your grave. Well, there's sometimes we have to kind of pierce through that. And here are the times. So let's look at them a little bit one by one. So this is an exclusion from that rule. And it's for crime, fraud, or criminal communications. And that case is Decoteau and Merzinski, page 234. 234. What did the court say? Case at 234. Okay. And that case deals with a legal aid office. A legal aid office is searched for evidence that an applicant had applied for legal aid, reporting a lower income. Remember, yet last case, the poor kid who's 23 and earns like $1.50, right? And still didn't meet the low threshold. So this case is about someone trying to meet the threshold by maybe not telling the truth. That's what the case is about. So it's a search of a legal aid office for evidence, and the police say, we agree to receive the documents in a sealed envelope, because that way then just the judge can see it, make a determination, it's not out in the whole world, right? Pending the judicial determination, so the judge can look at it and make a decision whether or not it should be released. And the court says, well, the documents are not privileged because they were created before the relationship comes into existence. Information was fraudulent, the privilege does not protect disclosure. So what the court is saying is, although you have this duty of confidentiality, and it kind of steps over into the notion of privileged documents, they say no. The judge decides, no, these can be released, they can be disclosed because there's a crime, fraud, criminal component to the activity, right? It's not just talking about mergers and acquisitions, right? It's about, there's a criminal aspect to it. And we have an obligation as a society to uphold adherence to criminal law. So they say that the information might have been fraudulent. I earn $1, not $1.50, so I can make it under the threshold to receive legal aid. That might be a fraudulent, might be a statement by the client. However, that's the application. You haven't been accepted yet. That's the distinction between this. You haven't been accepted yet, so your duties of confidentiality are not triggered, are not crystallized, and there's a crime, there's a criminal component. So that's an exception to that notion of confidentiality. One example, or at least, of course, the confidentiality of communications between solicitor and client may be raised where there's a concern about disclosing of the client's consent. The law provides, however, or unless the law provides that the legitimate exercise of a right would be interfered with another person's right to have his communications kept confidential, and should be resolved in favor of protecting confidentiality. So the normal course is, if there's an issue, we're going to protect confidentiality because of its seminal importance to the relationship and the process. However, when you step into criminal conduct, fraudulent conduct, we have this exception. Smith v. Jones. What time is it? Smith v. Jones. We'll come back because Smith v. Jones is a big deal. So, just to recap, we're going to take a break in 1 minute. Just to recap, we're going to spend the last 10 minutes of today doing a fun exercise. Fun, so fun. Which means we're going to have to stop this at 10 past 10 because we're leaving. So take a 5-minute break and come back and we'll power through and then we'll have a fun must keep all information of the business and so on of your client, affairs of your client, confidential. Well, we've seen one exception, right? The exclusion for fraud, criminal conduct. Now we have something called public safety. And Smith v. Jones is it's a pseudonym, right? It's a made-up name in 1999. And what happens is it's a criminal case, and a psychiatrist, so it's not even a lawyer, but it's a psychiatrist, who interviews the accused and comes to the conclusion that, having received very specific information from the accused to future plans to harm, I think he says rape and kill, like he says to the psychiatrist, right, during an evaluation, court-ordered evaluation. And the psychiatrist says, wow, like this is really concerning, like, yeah, really bad. Like doctors have their own ethical, right, rules. And he says, the psychiatrist says to the defense counsel defending the accused who just told him all this bad stuff, and the defense counsel says, I don't want to really tell the court that because it doesn't really reflect all that well on my client. The psychiatrist says, dude, you've got to do something about it because I've got this information, I'm giving it to you. The lawyer says, no. The psychiatrist brings an application, hires his own lawyer, brings an application looking for court approval to disclose the information that the psychiatrist got, hired by the defense counsel, so it's under that umbrella of confidentiality. And the court says, we're going to apply a test. We love tests. What happens to that test, as is the case from time to time, it ends up in the or it'll end up in all of the code. So let's go and see, because this is an important one. Tell your friends. I need a reader for this important section. It's 3.3-3, which is easy to remember, right? So let's have a reader, and let's see what, the test is there. Let's see what our rule says. 3.3-3. 3.3-3. Reader. Whoa, I gotta see. Good. Jean?
Yes.
3.3, go.
A lawyer may
What's the title?
future harm / public safety assessment.
Okay.
First, a lawyer may disclose confidential information, but must not disclose more information than is required when the lawyer believes on reasonable grounds that there is an imminent risk of death or serious bodily harm, and disclosure is necessary to prevent the death.
So we have a test. We have a test in Smith v. Jones as a case, and that test trickles down into our rules as a rule that says, yeah, we get it, confidentiality, good stuff. However, a lawyer may disclose, optional, not mandatory, right? It's not compelling you to disclose, but it says you have the option. And when do you have the option?
There's a risk of serious bodily harm or death, dangerous, imminent, or
Yeah, exactly. So you've got a nice test. You got a 3-part test. You have to satisfy yourself. Can I disclose this? Question 1. Is there clear risk, identifiable person or group? So in this case, I think it's prostitutes, right? And I think, in fact, it was even so specific that he said small frame like women, right? Like, so not just any prostitutes, very specific. Is there a risk of serious bodily harm or death? I think, threatening death. And is the danger imminent? And I forget, but I think it was like, this weekend I'm going to go on a spree or something like that. That the accused tells the psychiatrist in Smith v. Jones. So we have a nice test. And you know what's just fascinating? If you go to commentary 2, 3.3-3, lo and behold, what do you find there?
it says the Supreme Court of Canada has considered the meaning of the word serious bodily harm in certain context, which may inform a lawyer in assessing whether disclosure of confidential information is warranted. In Smith v. Jones, paragraph 83, the court observed that serious psychological harm may constitute serious bodily harm if it substantially interferes with the health or well-being of the individual.
So we got the model code downloading in HIP. Yeah, exactly. Not only adopting the test and the rule, making specific references to Smith v. Jones in the commentary. Read the commentaries, they're all good, and they put a lot of meat on the bones. So in Smith v. Jones, the judge ruled that the public safety exception, which pierced the confidentiality veil, and doctor-patient, that's as a psychiatrist, released the psychiatrist from his duties of confidentiality to disclose to the police and the Crown the statements made by the accused. And so we've got case law trickling down into our code and into the provincial rules as well. That's an important exception and so Smith v. Jones is at page 239. That's your page reference. And 239. And at 2, yes. So if you go to page 239 for the case of Smith v. Jones, you can read all about it. It's gruesome, and I'll take your attention to pages 242 to 243, which does, just we did now in the class, talk about how it ended up being in the model code under 323. This one actually references the British Columbia Professional Council, so it landed in that province's rules, but it's the model code, you'll find it in Ontario. No problem. Okay. Good. So, Supreme Court of Canada, you know, a bunch of smart judges, they like to write things. There's a dissent. And the dissent reads that there'll be a chilling effect if the majority rule is the rule, because that's the decision of the Supreme Court, right? That's the rule, you're all bound by it. But the dissent, which someone just said, when you get a case you don't like, read the dissent. Maybe there's like a little germ there for you. The dissent says there's a chilling effect if you breach privilege, they mean confidentiality, that notion of what the client tells you, and discourage those in need of treatment through consulting professional help. So, I guess that the accused murderer is going to read the Supreme Court of Canada decision, but I mean notionally, there's a chilling effect, right? And they say it promotes silence, not sitting. So that's the dissent on that. And so you'll see this is one of those FYI things in December of 2017. So 2 years ago almost, there's an e-bulletin lands in your inbox that talks about the rule and Smith v. Jones with some guidance for you. Okay? And what's our third exception, or third way in which courts have said confidentiality, good, but non-impenetrable? That is innocence at stake. So this is a case, R.D. McClure. So 2001, criminal case, civil case. The criminal lawyers want access to the civil file. And they say, I need to make full answering defense. The resistance is, no, it's privileged, confidential. Trial judge order production of file. Appeal. And on appeal, the court says, privilege is important. Privilege, confidentiality, they're kind of conceptually similar, but we're talking about protecting the information that the client gives you, right? They say there's an appropriate test for determining whether it may yield for the accused to make full answer and defense. And the test is stringent. Is the innocence at stake? So, the exception to the notion of keeping everything confidential or privileged, as the terms are used, is if I don't get access to the civil information, I am disadvantaged in my criminal proceeding, and my innocence is at stake. Because the worst thing that can happen in criminal cases is
Innocent person is
going
to their own person.
Orange jumpsuit, bars, right? Your liberty is taken away, your freedom is taken away. Civil, you gotta pay something. So in McClure, it's not met. The facts don't meet the test. But the important part is the test has been established. So now you have it. So now you have it. If there's innocence at stake, and remember, presumption of innocence until proven, and you need to have a valid defense. And then there are some legislative exemptions. These are statutory, right, where the government says, yeah, confidentiality, all good stuff, but we have an Access to Information Act And you can't get access to information if every time you make an application, someone says, sorry, confidential and privileged. Law Society, and we know this because the Law Society's mandate is to investigate lawyer misconduct, but if you say, nope, I can't give you my client files because they're all confidential and privileged, well, they can't discharge the mandate, and AML, which is anti-money laundering legislation. So here's the case of Goodis, Ontario, and this page reference is, did I give you McClure? Page 251 is the page reference and goes to page 256. And this is Goodis, the Goodis case, FIA, right, Freedom of Information, is page 259. Pardon? Comment? No? One?
Well, we were just talking about.
Oh, okay. So, and this is a case of Freedom of Information application, and the Supreme Court says for this legislative exemption to exist, the test is absolute necessity. And in this case, they said, well, we haven't found the facts to support absolute necessity. But again, we have the test. Just because it doesn't unfold in a particular way in the case that creates the test, the important part is the test. Like sometimes a case becomes notorious and helpful and is referred to constantly, not because of what happened in the case, but because of some principle or test or something that the court establishes that we use over and over again. Happens in many areas. So that's the test for legislative. Okay. Another legislative exception is Law Society demands, right? We know that because of the mandate. And remember Mr. Merchant, right? Tony Merchant, class action lawyer. In 2008, he's in Saskatchewan, and in 2008, it's not that funny, the wife complained, so Merchant has a class action practice. One of the clients in the class action is husband, and there's some kind of settlement or award, and each of the members of the class action, after Tony gets his little cut, nothing wrong with that, get $50,000, whatever. And the wife, the ex-wife of one of those people, complains and she says, well, her husband's a lawyer, paid the settlement for residential school claims to him instead of into court, which was a forfeit. So she can have access probably for something like that. She complains to the Law Society about the conduct of her husband's lawyer, Merchant. And the Law Society finds that their act in Saskatchewan permits the request to deliver any of the records because there's a positive obligation on the Law Society to investigate complaints, and the only way to get the information is to get the client file, right? It's another example where that notion of the bubble of privilege is pierced. And AML, right? And we know by AML legislation that lawyers cannot receive more than $7,500 in cash, yeah, because of the government regime. And if that has to be investigated for anti-money laundering, that's considered another example of where that notion of confidentiality can be pierced because we're trying to prevent money laundering, right? Proceeds of crime.
Fraud, yeah.
That's another example. Okay. So now we have this notion of confidentiality and privilege, and they're closely tied, they're closely related. And we have our model code at 3-3.1. Okay, so let me tell you the Law Society and Merchant case is page 261, okay? And the AML case is page 361. Okay. So, confidentiality and privilege. So what our model code does is it makes a distinction. And they say confidentiality is an ethical duty. Guess what? You're in an ethics class learning about duties to your client. Confidentiality is an ethical duty. Privilege, this is where it's important to have like a little bit of a distinction. Privilege is a legal duty. It's not like ethical duties. They spring from, the philosophers and case law, and a bunch of people sit in a room and they write out a model code, and then all the provinces write out a model. That's how those are created, from notions of fairness and client duties and obligations, whereas privilege is a legal duty. It's created by case law. It's created by case law, sometimes by statute. And confidentiality applies to all the information from the client. Everything. We've got a few exceptions, fair enough, but it applies to everything. It's unending. It's like a blue sky, forever. Privilege has limits. It's quite different. It's limited to information regarding legal advice, and it ends if the information must be communicated. Must be communicated, for example, law society, court order, compelled by law otherwise. And so privilege mainly relates to evidentiary issues. It's much more legal in its essence. And why do I say here? Commentary 5B. So 3.3-1.1, 3-1.1, 3-3.1. I have a different reader this time, someone that hasn't read today. 3.3-1. No, we read that, right? Commentary 5. Oh, okay. 5B. Okay, so just read commentary 5B of 3.9. Your next one. Yeah, me.
Generally, unless the nature of the matter requires such disclosure, lawyer should not disclose having been consulted by a person about the given matter, whether or not the lawyer find it shall be established.
What bell does that ring for us? What bell does that ring? B. Generally, unless the nature of the matter requires disclosure, a lawyer should not disclose having been B. consulted by a person about a particular matter, whether or not the client-lawyer relationship has been established. What does that remind us of? Stop drinking. These cocktail parties are freaking brutal on your career. So yes, it's the casual client, it's the cocktail party, it's the whether or not they retain you party. It's the what does the client think party, right? So,
I have a question.
yeah.
If we forget for a moment about the lying and fraud part of the application for legal aid, how do we match this with the legal aid case
Where the documents were
worked over, yeah?
Yeah, because what the court says is it's a privilege, not a right, to have legal aid. You have to apply and meet the standards before you are accepted, and then once you're accepted into that, that's when you can start talking about your confidential information and so forth. So the information you provide on the form is in order to trigger the confidentiality relationship. Plus, it was a fraudulent
But before even filling out the application, hi, who are you calling for? Well, I've been charged with murder. And like there would have been a conversation, first of all, to sort of say, hey, this is my legal issue, before a form was even filled out, which is akin to me to a cocktail party.
Yeah. You could be right. You could be right. That could be the interpretation depending on all the facts. How much they say, what they expect, what they understand to be the case. If they're told, sure, come on in, but we can't take you as a client until something depends on the evidence, right? Okay. Yeah, good point. So confidentiality and privilege, we've got the code, right? And confidentiality is ethical and broader than privilege, right? Because privilege can end. Privilege may have a life cycle that may end. And it's an evidentiary rule of law referring to the legal right of an individual to withhold information from an opposing party, court, tribunal, investigation. All privileged information is also confidential, not all confidential is privileged. So it's kind of like a shield. I have like a visual I used to do. You know, like a shield. And you're protecting this little privileged information. You're protecting it. You're holding up this shield to protect it. But you're only protecting it during some kind of legal ongoing issue. Your confidentiality is like a blue sky. And this goes on forever. You say, these documents are privileged. Here's why. We have a hearing about it. This is the determination. It may end. If they're made public, it could end, and so on. So it's a very legalistic description of privilege and a more general ethical duty of confidentiality. Subject to exceptions. It goes back here. So here's a visual that compares the two, right? Type of duty, ethical, legal. Broader relates to evidentiary issues. When unending, your confidential, even if your client writes a book about what happened in the case, it's unending. Unless law, society, and so forth, right? This one ends when the legal duty ends. So there's a snapshot of how to compare the two concepts for yourself. This one relates to all clients. This one is limited to private communications between the client, and it ends with the legal duty of privilege, and it's associated with evidence. So that, for example, if you have a document and you say, no, I'm not releasing this in our civil litigation because I'm claiming privilege. The rule is that it's limited to communication. So if the document sets out 10 pages of facts and 1 page of legal advice, and therefore I think you should do A, B, and C, guess what? That little portion is the communication, that's privilege, but the 10 pages of facts, off you go. So you redact. You redact the portion that is, you're claiming privilege. So good luck claiming on the whole document. Whereas confidentiality, it's a defining feature. It's a defining feature, right? It's one of those basic ethical concepts that we carry as lawyers. Oh, these are theories as to why confidentiality is important. We have exceptions, we know them. Oh, we have our exceptions. We also know that you have to defend yourself against misconduct. You may have to, these are more sort of technical reasons. You may have to be able to disclose confidential information. But if you ever are in a position where you do have to disclose, there's always this limitation. No more than is required. Only what's required. If only 2 documents are required, you don't hand over 4 USB sticks of information. So it's limited, and you can do so if you need to consult another lawyer, right? Because they need to know what the heck's going on, or if you need to collect a fee. Whatever. Every judge was a lawyer once. We have to collect our fees. Okay. Law Society and Savone are ordered to, that's just an example of a case. I don't think it's even in your book. Just an example of where Law Society gets to see your documents. And now we have this other little nuance, this little subset of privilege, which is solicitor-client privilege. Solicitor privilege must be as close to absolute as possible. The court tells us that. Now we're going to zero in on this notion of solicitor-client privilege. Not privilege against like a document. It's not dependent on litigation, and it does not expire. It does not include physical evidence, but does include the communications that lead to the evidence. We've got that Ken Murray kind of notion in this area. So solicitor-client privilege includes, or is part and parcel of being in-house counsel. In-house counsel in Alberta University of Calgary case, and the court describes it as a substantive rule. As a substantive rule, solicitor-client privilege must be as close to absolute as possible. It has to be, but does in-house counsel professional status lawyer override a position as employee and become a whistleblower? So you're a lawyer, your corporation's dumping toxic waste into the drinking water, you know this. You're a whistleblower, which is usually an anonymous process. And so this case talks about the whistleblower role being overriding your in-house counsel obligations or incentives to report wrongdoing. So that's considered a more important social goal to uphold over privilege. And by the way, if you're giving business advice and not legal advice, you can't claim privilege, right? Because in-house counsel sometimes give business advice, like they give a wide range of advice, human rights, employees, and so forth. Okay, R.B. Murray. And we know that as a result of the R.B. Murray case, which was Bernardo's lawyer, that case had a discussion of obligation not to conceal evidence, like don't do it. Solicitor-client privilege covers communications, not the physical evidence. So the discussions between client and the lawyer might survive the privilege, but the thing, the bloody knife, the smoking gun, in this case the videotapes, are not covered. So that's where Murray went off the rails. Oh, okay. And so then we have another example of where the Law Society talks about that notion of physical evidence. Privilege does not cover physical evidence. So solicitor-client privilege, those communications, litigation privilege. Those documents produced with an intention to litigate. So you are retained, you have all the source documents. Now you start writing memos and opinions and all those things that are for the purposes of litigation. Like litigations, there it is, we're going there, I'm going to prepare all these documents. So they are produced with an intention to litigate. They can include documents, opinions, experts, and so forth. Litigation privilege, unlike legal advice, which is solicitor-client privilege, where you have communications about advice, expires with the end of the litigation, right? Because once the case is over and you put in all your documents to prove your case, it's evidence, judge writes the decision, it's all there, so it ends. And it attaches to documents prepared for the dominant purpose of litigation. So it can't be a document yet. It can't be just a document, well, we're in litigation, everything I prepare is covered. It's not. It has to have this test of dominant purpose. And so now we have another distinction between litigation privilege and solicitor-client privilege, right? And here's a visual. This one protects communications. This one is for documents with the dominant purpose of litigation. This one, the communications are protected forever. This one ends with the litigation that gave rise to it. And one of the leading cases in that is blank, which is, I don't think it's in your book, but the University of Calgary cases, which we just touched on, page 264. Another, this is it. So the blank case, I've given you the page reference that I'm trying to get us to. Okay, blank, 264. This is a 2016 Supreme Court of Canada case, protection of litigation privilege, not in your book, but it builds, so this case builds on the blank case by confirming fundamental importance of litigation privilege. So there's a good discussion there. And the University of Alberta case, protection of solicitor-client privilege communications. And in that case, the Supreme Court said in that case that Alberta 264, right? I just said that. Okay. Central question was whether the statutory language was sufficiently clear, explicit, unequivocal to abrogate solicitor-client privilege. And the majority in the Supreme Court concludes that the Alberta legislation was not sufficiently clear. So the message there is if you have a piece of legislation or a statute that says you can pierce the solicitor-client privilege concept, it better be clearly and explicitly stated in your legislation. Pritchard, okay, page 581. This is an Ontario Human Rights Commission case against a former employer. And the appellant brings a motion before a judge for production of all documents that were before the commission. So it's a court proceeding, but the appellant wants the documents at the tribunal hearing, the Human Rights Tribunal hearing. So similar to that notion of I want the civil stuff in a criminal case for that, because it'll help me with that. And my innocence is at stake, so it's another example of your scene. This one wants the commission documents. On appeal, the sole issue of the production of legal opinion, a three-panel court of the divisional court upheld the judge's decision. Set aside orders pertaining to holding of the opinion was privileged. So the legal question in that case was, is a legal opinion prepared by in-house counsel protected by solicitor-client privilege in the same way as if prepared by outside counsel? The answer is yes. So working in-house, where your only client is your employer, you have the same obligations as when you have the individual who is your client. So it applies to a broad range of communications between lawyer and client. Client could be a corporation, could be the government, and applies with equal force to advice given by an administrative body, by any house counsel. So your client in that case was the rights tribunal. They have their own counsel sometimes. Federation of Law Societies of Canada, the authors of our code, at page 267 through 275, and this is the AML exception to the notion of privilege and confidentiality for the good reasons that we as a society want to promote and prevent money laundering, and therefore privilege cannot be used as a protective shield in those cases. And we have bodies that exist, right? The FINTRAC and international bodies that are trying to combat anti-money laundering or money laundering because it's an international problem, right? Sale of arms here, money flows there, terrorist financing over here. So this case talks about solicitor kind of privilege and anti-money laundering. Okay, and so the Federation of Law Societies, they don't just write the model code. They do other stuff too, right? And in this case, they wrote 2 draft rules for the no cash rule, right, the 7,500, and also client identification and verification rules, which requires you when you take on a new client to take a passport picture, verify their identity, Google them, be satisfied that you know your client, that you know who this is, and that you won't be handling money or funds from someone that is not trustworthy. Client can waive privilege. It must be clear, freely made, and informed. The client has the choice. They have to understand that. And it's best if the waiver is express. Write it down, email it, fax it, staple it to your book. Once the client has waived, it's not possible to get it back. So client's going to consent. You have to be fully informed. Oh! So, any questions today or otherwise? You could always just email me, or I'm happy to stand. So today, fun exercise. Fun. You won't want to leave the class when you end. So here are the rules of engagement for today. So today's halfway through our course. We're going to do a micro assessment. You are not going to be marked on this, other than participating and actually doing it. So there's no marks assigned, but you have to do it. And it's going to go with that notion of participation. Here are the rules. I'm going to flash it in a minute. We have a question. So what you're going to do is you're going to have 9 groups of 4. So 4, 4, 4, 4, 4. I don't care. 4, 4, 4, 4. 4 people get together. I'm going to show you a question. You're going to work on it together. One of you is going to type up an answer and email it to me. So I should get 9 emails by the end of class today. When I get back to my office, I'll have all these emails, right? You're going to have 10 minutes. Time pressure. Here's the question that you're all going to work on. One of you is going to email me with the answer. In your email, include the people in your group. Like include the names so I know who's doing it, right? Give me the 4. Ready? Ready? This is for something else, so just do this one. Just do points 1 and 2. So Peter Parker, don't do this one because that's for something else. Okay? And it's now, look at that, 10 past. Go. 10 minutes, clock is ticking. Group of 4, start working. Someone type me the answer as you're talking. Call for names. So I'm going to wander around and hover. 10 minutes, kick off.
Can we get together?
Okay.
Okay, 4 there, I guess.
Ignore.
So 1, 2, 3, 4.
Yeah.